let's get into the Scotus story because I think this is very, very concerning. I don't know if everyone is familiar with this, but right now, actually, the Supreme Court is hearing a case about the government's involvement with social media. So this is very concerning. You guys know how I feel about the Twitter files. I covered those extensively on this show, but this situation has not gone away. And now it is actually at the Supreme Court. This is a different case, but we're running into the same issue. The Supreme Court seems favorable to the Biden administration over efforts to combat social media posts. Here we go. The Supreme Court seemed likely Monday to side with the Biden administration in a dispute with Republican-led states over how far the federal government can go to combat controversial social media posts on topics including the pandemic and election security in a case that could set standards for free speech in the digital age. The first question I have is controversial, right? Who decides if it's controversial or not? Well, typically that would be the platform. But as we learned from the Twitter files, the government actually was contacting Twitter executives and telling them what to remove and what to suppress on their own platform, right? That hasn't really disappeared completely. We see that happening still with Facebook. Mark Zuckerberg talked about this to Joe Rogan, that he was told to suppress the Hunter Biden laptop story, correct? So that means that the government would decide what they consider to be controversial. We're living in very dangerous times. The justices seem broadly skeptical during nearly 2 hours of arguments that a lawyer for Louisiana, Missouri, and other parties presented, accusing officials in the Democratic administration of leaning on the social media platforms to unconstitutionally squelch conservative points of view. Lower courts have sided with the states, but the Supreme Court blocked those rulings while it considers the issue. So here's something I want you to think about. Whether you're liberal, conservative, or let's just say you may not have a political ideology, I don't want you to focus on the fact that the speech that was suppressed or squelched in this article was conservative points of view. It really doesn't matter. It doesn't matter if it was conservative. It doesn't matter if it was liberal. It doesn't matter if it was progressive. What matters is that the speech is being removed. It's being suppressed. People are being removed from platforms. People are being deplatformed. I've seen a lot of people come and go on this platform, on Twitter, because of this issue. Same thing with Facebook and the same thing with Twitter. Several justices said they were concerned that common interactions between the government officials and the platforms could be affected by a ruling for the states. In one example, Justice Amy Coney Barrett expressed surprise when Louisiana Solicitor General J. Benjamin Aguinaga questioned whether the FBI could call Facebook and X, formerly Twitter, to encourage them to take down posts that maliciously release someone's personal information without permission, the practice known as doxing. Do you know how often the FBI makes those calls? Barrett asked. Justice Brett Kavanaugh also signaled that a ruling for the states would mean that traditional everyday communications would suddenly be deemed problematic. The case Monday was among several the court is considering that affect social media companies in the context of free speech. Last week, the court laid out standards for when public officials can block their social media followers. Less than a month ago, the court heard arguments over Republican passed laws in Florida and Texas that prohibit large social media companies from taking down posts because the views that they express. So think about this. It was just a couple of days ago, there was the TikTok bill, right, that passed in the House. And that's been very concerning for people. And I told you, even with that bill, it wasn't just about TikTok. It's also about websites that the government can deem inappropriate. It's also about apps, them having some type of control and telling you which apps that you can actually download. So this goes further than TikTok. It goes further than Facebook. It goes further than Twitter. And I've said before, this is a form of fascism. I really do believe this is not just about this case here with Missouri, Louisiana. This is also about the suppression of international information. They want to suppress different voices or voices that have a different opinion about the war in Ukraine. They want to suppress voices that are pro-Palestinian. And we've seen that happen for years on Twitter, at least I have, the pro-Palestinian voices. They want to suppress voices that have compliments for Russia, right? And they want to uplift and boost the voices that actually back the State Department narrative. So this is a very scary time. And I never really thought that in my lifetime I would see this happen, because I feel like we went past the McCarthy era and here it is 2024 and we're trying to go back to the McCarthy era. Very telling times. And it also brings up the situation with Julian Assange. Why is Julian Assange imprisoned? Because he published information that showed that the US government and the US military had committed war crimes, that they were actually killing innocent people. How many more? How many more Julian Assanges? How many more does there have to be before people really push back and fight back against this? If we don't have our speech, what do we have? A little bit more here, and then we'll get to Matt Taibbi. The cases over state laws and the ones that were argued Monday are variations on the same theme. Complaints that the platforms are censoring conservative viewpoints. And I would say not just conservative viewpoints, because they heavily censor and suppress leftists as well. And by leftists, I do not mean Democrats. I mean people that are progressive, socialists, Marxists, communists. We are heavily censored. The states argue that White House communication staffers, the Surgeon General, the FBI, and the U.S. Cybersecurity Agency are among those who are coerced changes in online content on social media platforms. And we'll go to this piece here because it starts to get to the audio portion, and I actually want you to hear the audio portion. A divided Supreme Court put the Fifth Circuit ruling on hold in October when it agreed to take up the case. A decision in Murphy v. Missouri 23411 is expected by early summer. So let's go ahead and get into the audio that I want you to hear. And shout out to Glenn Greenwald for capturing this. I want you to hear what Justice Ketanji Brown Jackson argues in this case when it comes to the First Amendment. Now, remember, this is the person that Joe Biden selected, and everyone said, a lot of people said kudos to Joe Biden because he chose a Black woman. And I was one of the people that said, okay, yeah, she's Black, but what is she for? And people just kind of gave me looks and stares. I'm like, oh, how dare you? How dare you? It's about representation. Representation is great, but who is she for? And I argued back then she would be for corporate interest. I said if Joe Biden selected her, she's not going to be for a progressive view. She's not going to be for a lefty view, a socialist view. She's not going to be for the people. She's going to be for the corporations and the military industrial complex and censorship. We'll go into the first audio here because it appears I was correct about her. So shout out to Glenn Greenwald for capturing this. It says Ketanji Brown Jackson grills Louisiana. Ketanji Brown Jackson grills Louisiana Solicitor General, says that because the government can occasionally censor, they can also occasionally coerce. Listen to this, guys. I can't make this up. This is wild.
But whether or not the government can do this is something I took up with Mr. Fletcher, depends on the application of our First Amendment jurisprudence, and there may be circumstances in which the government could prohibit certain speech on the internet or otherwise. I mean, do you disagree that we would have to apply strict scrutiny and determine whether or not there is a compelling interest and how the government has tailored its regulation?
Certainly, Your Honor. I think at the end of every First Amendment analysis, you'll have the strict scrutiny framework in which, in some national security hypos, for example, the government may well be able to demonstrate a compelling interest, may well be able to demonstrate.
All right. So not every situation in which the government engages in conduct that ultimately has some effect on on speech necessarily becomes a First Amendment violation, correct?
Maybe not necessarily, Your Honor. I guess the top line question I would ask is, has the government set out to abridge the freedom of speech? And in this case, you see that time and time again, because if you control...
That's not the test for First Amendment violations.
Your Honor.
So notice how she interrupts him here. She is honestly arguing for the fact that the government should be able to bypass the First Amendment and push back on the First Amendment. Why do we have a First Amendment? Why do we have a Second Amendment? I feel like these rights, or our rights in this country, are just being chipped away like little by little. Like this is insane. And this is dangerous. Because think about it. People are sitting back and they're like, well, she's, liberal, and Joe Biden's the president, he's Democrat. That won't always be the case. The decisions that the Supreme Court makes, it doesn't matter who the president is. It doesn't matter if the president's a Democrat or a Republican. So to me, it's just like, this is very dangerous.
This flows from the plain text of the First Amendment, right?
No, I understand, but we have a test for a determination of whether or not the First Amendment is actually violated. So in certain situations, the government can actually require that speech be suppressed if there's a compelling interest, right?
No. So she just said the government, in certain situations, the government can actually push for speech to be suppressed. In what situations? And who decides what those situations are? The government? This could be anything, you guys. This can extend beyond this. Like, he's talking about conservative speech. They're talking about social media platforms. What about protest? What about those of us that organize online? People who organize actions and protest online. How far can this really go? I'm always thinking down the road. Like, I'm thinking, okay, this law says this right now, but what will that mean 5 years from now? And how can they expand it?
Can, Your Honor, and I guess what I would say is that the courts below never got to strict scrutiny because the government never raised this. This has never been litigated. The question in this case is whether at the front end, the government itself has undertaken action.
Is the coercion, is the state action, right? That's the question in this case.
And I would urge the court to address the state action issue just like you addressed it in Bantam Books. Use that term 4 times in Bantam Books.
And could I just understand, because it seems like an extremely expansive argument, I must say.
Okay, that's the first clip, and I want to show you the second clip as well. Again, shout out to Glenn for this one. And this one, she actually doubles down. Like, this is, it's wild, man. This is the second clip here. This is still Ketanji Brown. Listen.
Justice Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government.
I'm sorry. That is very low.
Justice Jackson?
So my biggest concern is that your view has the First Amendment hamstringing the government in significant ways in the most important time periods. I mean, what would you have the government do? I've heard you say a couple times that the government can post its own speech, but in my hypothetical, kids, this is not safe, don't do it, is not going to get it done. And so I guess some might say that the government actually has a duty to take steps to protect the citizens of this country and use.
Pause. This is something that they tend to point to. The government has a duty to protect the citizens of this country, right? And that's the argument that some of them will make. We have to suppress this person. We have to deplatform this person. We have to censor this person because we're trying to protect the people of this country. Protect them from what? And I'm here to tell you, it's not really about protecting the people of this country. We have actual hate groups in this country. So it's not about protecting the people of this country. This is just another way for them to be able to point at information that does not fit their narrative, the narrative of the military industrial complex, the narrative of the deep state, to point to it and say that it's disinformation, and to use that as an excuse to remove that information because they don't like for that information to get out there, right? I told you about how the Biden administration was surprised at the response that they received in reference to the war in Gaza. They were not expecting thousands of people to come out into the streets and be for the Palestinian people. They weren't expecting that, and they didn't know how to respond to it, right? But the information was released and the information was received that let a lot of younger people know the history of the creation of the state of Israel and how the Palestinian people wound up in the position that they're in the first place. So, see, that was not supposed to happen. People were not supposed to find out about that. We were just supposed to believe the Zionist propaganda, which is also supported by the State Department. So now they're trying to find other ways. TikTok was just the beginning. They're trying to find other ways to prevent information from getting out. Now, people point to the books. People are like, they're banning books in Florida. It's not just about banning books. It's also about suppressing information on social media, Google, the internet, all of it. We receive information in many different ways. And then what's next? I told you the TikTok bill is like the Patriot Act 2.0. They want to spy on us. They want to listen to what we say in our own homes. What happened to our right to privacy? I told you, little by little, they're trying to take our rights away. They're trying to take your Second Amendment right away. And I said it before, I am pro Second Amendment. And I say this, you may not hear this sometimes. People say they're not used to hearing that from Black people. Bump that, especially if you're Black. Especially if you're Black. I believe that everybody has the right to protect their self and their family. That's how I see that. People may say that's a conservative view. I don't think so. Let's finish this part here.
Seem to be suggesting that that duty cannot manifest itself in the government encouraging or even pressuring platforms to take down harmful information. So can you help me? Because I'm really worried about that because you've got the First Amendment operating in an environment of threatening circumstances from the government's perspective, and you're saying that the government can't interact with the source of those problems.
And Your Honor, I understand that instinct, and I guess what I tell you is
Okay, so she is basically advocating again for the government to be able to go around the First Amendment. The First Amendment exists for a reason. Like, this is absurd. This is absurd. So Matt Taibbi actually weighed in on this morning on Rising, and I believe he's also on Glenn Greenwald's show as well. He'll probably be on a number of shows discussing this. I don't know if I'll be able to get him. I feel like Matt was just on here. I don't like to invite people on too much, like back to back, because then I don't want people to feel like they're being bothered, like, like, damn, when I just on there, like that kind of thing. But he'll probably be on a number of shows. I can try to see if I can get him, but he's probably really busy right now talking about this. But he was on Rising this morning talking about the Scotus free speech issue. And remember, Matt Taibbi was the author of the Twitter files. So again, the Twitter files was just the beginning, and we're still seeing this issue with free speech on social media platforms. Here we go.
Well, first of all, that clip by Ketanji Brown Jackson, that was kind of terrifying because the entire purpose of the First Amendment is to restrain the government. It's not to restrain the public from getting in the way of government action. It's the opposite. If it restrains the government, that's a good thing. That's sort of the idea behind the statute. In this instance, The reason this suit is being filed is because the plaintiffs in this case, in particular, Dr. J. Bhattacharya and Martin Kulldorff and Dr. Aaron Hariati, they had their speech suppressed because they were contradicting a false government official opinion. And this is the entire purpose of the First Amendment, is to prevent the government from creating a hegemonic opinion that cannot be challenged. That is why we have a free press. And that was the essence of this case. And the government was allowed to argue the opposite.
Matt, devil's advocate here, I'm very sympathetic to the argument that Twitter's actions in response to the government pressure were censorship and were wrong. But it does seem to me that there's a separate question here, which is whether or not the bad actor here, or the but-for clause here, is really the government's actions, or the company's choice to kind of succumb to that sort of soft pressure. There did seem to be a lot of discussion of this case, National Rifle Association versus Volo, and it did seem that most of the judges, including the liberal judges, not exclusive to them, were making the case that case featured direct coercion from the government of a business that's saying that they were going to blacklist a business if they did not censor or reject the NRA. In this case, I know here on the show we talk about the kind of soft pressure and the possibility of threatening social media companies with Section 230 rule changes that could basically end the ability of a lot of these businesses to function and the like. But I'm wondering if in this case and in these oral arguments, that kind of more direct pressure was raised, or is the question really whether the government is allowed to flack, if the government is allowed to reach out and make its preferences known to a social media company, as long as a social media company has the power that something and isn't feeling, I think, really directly coerced with real threats of some damage, pecuniary or otherwise, happening to their business if they don't comply with the government's requests.
So this is where I disagree with Bree's take here, because one of the things I will say is I think it's given a little too much trust that the government is going to do the right thing, which I don't trust. I don't trust the government's going to do the right thing, particularly when it comes to free speech or censorship or anything like that. I just don't trust that they're going to make the right decision. They're going to do what's in their best interest. They're going to do what works best for the deep state and the military industrial complex and Wall Street. So I disagree with her on this point here. So I don't trust that the government would do the right thing. And then also, I think that for those social media platforms, if they were presented with that option, that the government would say, you know, this is what we're laying out for you here, but you're still in power of it. I would actually say that at that point in time, the power of the owner of the platforms has already been either diminished or removed. And I say that because once the government is telling you how to run that platform, you don't really get as much say as you think you do. And I think Elon Musk is seeing that, right? Like Elon Musk is probably sitting back like, I'll be damned. I wonder if Elon Musk is ever sitting at home and he's like, why the hell did I buy this platform? He's right, like, this is too much of a hassle. But yeah, I just don't trust that the government will actually will do the right thing.
Well, Brianna, I mean, that's a good question, but there were so many instances of the government making that overt threat that you refer to that the Deputy Associate Solicitor General, Brian Fletcher, had to list them in advance, essentially introducing them as sort of adverse evidence at the beginning of the case in order to downplay their seriousness. In the summer of 2021, the president himself, Joe Biden, said that Section 230 needs to be immediately revoked because the companies are promoting falsehoods. There was the same thing was said by the White House press secretary, Kate Bedingfield. The Surgeon General said something very similar, that we need to take appropriate regulatory measures in response to this kind of misinformation. Renee DiResta, who is the research director of the Election Integrity Project, which was sponsored by both the State Department and the Department of Homeland Security, talked about using Section 230 to bring these companies to heel. This was an overt threat. And also, I would add, in the Twitter files, we found ample evidence of correspondence among Twitter's executives in which they described how they understood the regulatory changes that were being proposed as a threat that they must answer if they, in order to get the government off their back, they would have to comply with the government's request to let them in on the moderation process. So we saw that in the internal correspondence. So there's both overt and less obvious evidence of this. That's not missing from the case. That's a feature of the case. In fact, the government going public with those threats, I think, was sending a very strong message that not only the companies would hear it, but that the public would hear it. So I disagree with the notion that they didn't make that overt case, even though Fletcher said that.
And can I just make a quick follow-up to that?
Before Bree responds, one thing I want to tell you, I'm concerned about going into November. If this goes through, and we're talking about this ruling, if it happens from the Supreme Court, that the government can just kind of intervene even more so and determine what's allowed on these platforms. What does that mean in reference to presidential elections and platforms like Facebook or Twitter, or if TikTok's still a thing? What does that mean in reference to, like, let's say you're promoting third party or independent candidates. What if they deem that that is problematic for the American people because it takes away from, as they say, it takes away from the two major parties, and they decide to silence all the people that are promoting third party or independent candidates? What if they silence those candidates? Just something I'm thinking about going into November.
Do you have a sense that there could be a way to distinguish between, let's call it more soft pressure, the government saying, hey, I'd prefer that you don't let this fake post of a family member of a president stay up on Twitter, that request can be acceded to or denied, versus the kind of regulatory threats that were coming from the president? Do you think it's worthwhile to make that distinction, or do you think that both kinds of government contact with these kinds of companies should be precluded?
Well, let's just talk about what did happen, right? The analogy, and the justices compared it to what would happen with, say, the Associated Press or the New York Times. The analogous conduct would be calling up the editor-in-chief or the publisher of the New York Times, or let's just say a local television station, and saying, we're going to pull your FCC license unless you do X, Y, or Z, or unless you hold this story. That would be such an inappropriate call that, the person who even answered that call on the press end would be in serious ethical problems, I would say. But they didn't just do that in this case. They went straight to the heads of the company, but they also had an industrial scale operation to do this. It wasn't just occasionally, hey, let's make a phone call and make our feelings known. They had a sort of private highway to all of these companies where they were funneling mass requests. Now, what I would say would be okay and is appropriate, in fact, even desirable, is if the president gets up and uses the bully pulpit and says, you know what, I don't like what's on Facebook. They made a mistake here, here, and here. Here's what I think the truth is. And, we see these posts that say something else. That is the entire purpose of the bully pulpit. The president has an enormous megaphone to counter that kind of thing. What's not appropriate is doing it in private and coupling it with a threat. And that's what happened in this case.
Let me pause there for a second. This is a really good point here from Penny, from Facebook jail to real jail. Yeah, and I'm worried about that for people as well. We already saw some of this exchange in reference to Facebook and the government, of them telling, again, Mark Zuckerberg to suppress the Hunter Biden laptop story because it would harm, Joe Biden's presidential election. I mean, this is crazy. It's absurd. I don't want the government to control these to have any type of control over these platforms, whether they feel the information is negligent or the information is incorrect or not. I don't want them to have any control over that. And basically we will be living in this is my if I'm picturing this of just how bad this could go, as much as people point to North Korea and they talk about how the information that comes into North Korea is controlled. What do you guys think they could try to do here? Imagine if all the information, it gets to the point where all the information that we receive in this country is controlled by the government. So there is no, let me Google this information, and you don't even know if you're receiving the correct information. It's just what the State Department wants you to see. Imagine that. If they control everything, like people in North Korea, they don't even know, like a lot of these stories, these news stories that I talk about on here, they don't even know about it because the information is controlled, what they get to see and what they don't get to see. And that's like my worst fear.
Yeah, I've been looking at the case law for, job owning is the legal term here, where the government tries to extort a private actor to do something that they couldn't get through a legislative remedy or haven't tried to get through a legislative remedy. There are cases of, I think, phone companies having dealt with. There are some examples of the past, but it's not been a well-developed or well-fleshed out category of law. So look, it's an open question, obviously, because they're litigating it now, whether this contact was not just inappropriate, but unconstitutional. And if the Supreme Court ends up saying, as unfortunately looked like it might be the case based on their line of questioning yesterday, that, look, you might view this contact as inappropriate, but it doesn't actually violate the Constitution, then the question, I guess, becomes there could still be a legislative remedy. Congress could pass a law that precludes government employees of at least federal agencies. I think actually maybe they can't do anything about, members of Congress have very wide latitude according to the Constitution, but they could, similar to, the Hatch Act says you can't campaign on federal time or money if you're a federal employee. We could structure some policy for how federal employees are supposed to interact with social media companies or just the media in general. Do you think that's the direction? I hate to look to Congress for a remedy, but is that the direction we'll have to turn if the Supreme Court does not take up this question?
Robbie mentions the Constitution, and I'm starting to wonder if the Constitution even means anything anymore. Just like I'm starting to wonder about the Bill of Rights. Do they even mean anything anymore?
Or doesn't give us the answer I want, I guess.
I think it's going to be difficult, absent a judicial ruling that this kind of behavior is illegal. I would argue that it's already illegal. I mean, some of these agencies that were engaged in this kind of behavior by statute are prohibited from engaging in domestic propaganda, let alone censorship. So the idea that the State Department is doing this, or for instance, the CIA, which was participating in some of these programs, or FBI counterintelligence agents, the Foreign Influence Task Force, going after domestic speech, I think that's already against the law, but we need an affirmative high court ruling that says that in order to make it possible, I think, to make the legislative changes that we would want, or that I would want anyway. The problem is the enforcement mechanism is absent here. And incidentally, just to go back to the whole issue of threats and what is and is not allowed, the appellate courts that heard this case, and I was at the Louisiana hearing when there was a colloquy between the government and three appellate judges who they were very, very well versed in the case. They had read all the evidence, all the exhibits. They were clearly not happy about quite a lot of things, but they delineated a 4-part test that came from some lower court case. Brianna, maybe you can tell me what it is. I forget, but one of the standards was if the communications are phrased virtually as orders. And we saw that repeatedly in communications, both in the Twitter files and in the evidence that came into the complaint in Missouri v. Biden, which is now Murphy v. Missouri. The government would not be taking this tone with these companies if they did not have leverage over them. As you know, we've all been reporters. We've all been in the situation of having a government spokesperson sort of beg or plead, please don't write this or that, or I think you're making a mistake if you publish this. And they do so politely because they don't have any leverage to tell me what to do. I'm a member of the Fourth Estate. I have my own independence, and they don't have a right to tell me not to do it. Well, the tone is very, very different in these communications between, say, the FBI and these companies. There are letters that say things like, hey, we wrote you 6 hours ago. How come no action has been taken? Like, you would never get that just as a journalist. That is
Well,
Let me pause for a second. See, I remember when people were very like nasty towards Matt Taibbi when he released the Twitter files. I remember how Mehdi Hasan, was nasty towards him. I remember how they treated him when he testified in front of the House, in front of the weaponization committee. And I just remember, and I remember people telling me, who cares about Twitter? It's not a big deal. And I was like, well, no, this is a big deal. If the government was actually telling Twitter what they could or could not have on their platform, that actually is a problem, that they were telling them to remove accounts. And I just remember people like, oh, Matt's right wing. He's all conservative now. He's got a new grift and all the kind of stuff. And Matt Taibbi back then was even trying to warn people what this could escalate towards, that it wasn't just about Twitter. And here we are. Now we have Scotus dealing with this.
completely different kind. Would you?
Matt, I gotta say, I got some very impolite flack once from Chuck Schumer's office back in my Intercept days, but that's neither here nor there.
Well, they can be rude, but they wouldn't have an expectation that you would comply.
But no, but
I hear you that there's something different in tone.
But this is the problem. I mean, I do think this order language, or whether you're talking about the NRA case, that's really the crucial thing. And while I agree with you and Robbie about what I think the constructive outcome should be, I find myself on the fence about whether or not this is the right mechanism to enforce it. I think some of the statutory mechanisms that you raised before about what limits the government should impose statutorily on its ability to liaise with some of these companies seems right. But in this case, the way that this is being written up, and I admit that I have not read all of the briefing here, they say that they did not raise actually any of these kinds of orders or directives from the government in the case. I'm reading a write-up, a summary in Vox, where the strongest argument made is that the government, quote, entangled themselves in the platform's decision-making process, which I can agree is a problem and maybe should be remedied through some of these statutory means. But has there been a strong enough argument made? I think this is the question. Has there been a strong enough argument made that the kinds of emails that you have covered so well in the Twitter files really did constitute an order? Or did the plaintiffs here properly bring in and make the case that statements by the president or others about Section 230 were sufficiently coercive? Was that case made? Because I think that's a much stronger case than even plentiful emails, even nagging emails, even voluminous emails saying we don't like X, Y, and Z policy. I'm having trouble differentiating that from the kind of flacking that we know all exists in the realm of the media, traditional media.
I think the thing was, though, in those emails, because I remember going through many of them, is that it wasn't even just, I think you should do this. It was remove these accounts. Like, they had specific accounts telling them to remove from the platform or to flag them as Russian accounts, which many of those accounts were not even Russian accounts, is really weird. Like, so they were making demands. Like, the government was actually making demands, including politician Adam Schiff, who is really interesting. Adam Schiff, who was involved with the Twitter files as well, making demands towards that platform. And he just won the election for senator in California, which he proudly admits, basically he paid for that, right? Like, AIPAC basically helped him, get that seat. It's not like he kept that a secret, but it's like, basically, you scratch our back, we're scratch yours. So think about that for a second. The ones who are actually pushing for the censorship are the ones that are actually getting promoted.
Yeah. Again, it's so different from what goes on in traditional media. I mean, we did several Twitter file stories about, for instance, an episode in early 2017 where the Senate Intelligence Committee was not happy that the companies were stonewalling them on turning over evidence pertaining to possible Russian bot activity, or what evidence they did turn up they didn't like. And so right after those communications, hey, we need to see all this data, which they weren't entitled to, by the way. They asked for them. Immediately after that, they introduced legislation that would dramatically impact their ability to collect ad revenue from certain foreign customers. And so we see this back and forth within Twitter. Hey, we better do what they say and let them into this process of looking at our data on, Russians and all these other things, or else it's going to lower our bottom line. We are going to lose money. We're going to lose ad revenue. And they ended up proactively making a decision to forego that activity so that they wouldn't go ahead and pass that law. There was a similar episode where they were dragged to the Hill in order to come up with a plan for preventing the sowing of discord. This was presented to them sort of side by side with a big white paper that had been written by Senator Mark Warner, essentially listing a whole series of regulatory measures involving everything from Section 230 to the taxation of big tech companies. And, as the lower court judges said, you have to be sort of an idiot not to see what they were saying. It was like, a mob movie. Two judges compared it to a mob movie. They said, hey, it's a nice tech company you got there. It'd be a shame if something happened to it. And they, the companies certainly understood it that way. We see that from their internal correspondence. Now, the one thing I will agree with you on is that this case was not perfect in the sense that they didn't show a soup to nuts progression involving any one of the particular plaintiffs where the person was censored, and we know that they were censored because of a particular communication from the government. You can see the government saying, for instance, we don't want anybody who is creating content that would promote vaccine hesitancy. And we see that shortly afterwards, people like Dr. Bhattacharya or Dr. Kuldorf were de-amplified or removed from platforms.
Dr. Malone.
But that's not, a direct causal relationship that they've been able to establish. And I think that was the weakest part of the case. However, I think the activity itself was plainly illegal, but the problem is one of standing rather than legality.
Yeah. Oh gosh. I got to tell you, it is very concerning. I'm very concerned, and I don't know, man. Like I was worried about this when we were going over the Twitter files, and I was just like, how far is this going to go? Because it's not just going to stop at Twitter. They want to watch what we're doing, like, right? I mean, Edward Snowden, didn't he reveal all of this to us? Like, they want to know what we're doing, what we're saying, the conversations that we're having, who we're conversing with. Like, they want to know. They're trying to slowly remove our sense of privacy. Scary times, man. We got to push back on that.